Item 16 WPL 1530 of 2024 along with handbook 17 and 18.
These are the three chapters. 17 3826
नहीं 3826 18 है
अच्छा
और वो है 1544 में. इसका नहीं है.
That's the first one of 2006, in which the court has held that the irrigation division there is not an industry matter.
Same division is involved.
Same division is involved. And the second one is passed by the Honorable Division Bench of this court, madam.
It is also the same division.
No, madam. 2014 SCC online 2907.
This is which division?
This is it's related to the. This is of Jamshedpur, but it is not related to the irrigation department. It says that the department, government department, is not be considered as a the state of Jharkhand. Department of the state of Jharkhand is not be considered as a
Minor irrigation.
minor irrigation of government of Jharkhand is not considered as a industry. And the third one is the border passed by Malad. what starts at page number 21.
Read the reference.
Whether non-payment of due wages and regularization of service of Sri Ranjho Hembrang, Hemlal Kistu, Hriday Narayan Singh, Jaydev Prasad Singh, Girdhari Prasad Singh, and Mohan Lal Singh, all chautidars by the management employer, Executive Engineer, Water Resource Department, Secretariat, Devghar, and others is justified. If not, what relief they are entitled to?
Read the respective case of the parties. The workman.
The workmen and the management appeared and filed their respective written statement. The workmen have asserted in the written statement that all the 6 workmen named in Annex A of the reference were employed with the permission of the department on the post of Chautidar before construction of Secretariat Barrage against sanction and vacant post. The land of workmen was acquired in Secretariat Barrage and they were provided employment being land user except Hemlal Kisku, who was employed on the ground of being a member of the scheduled tribe. The workmen were removed from service for some period and due to movement of union, they were taken back on duty from March 1999 and they are working since then except Hemlal Kisku, who died before the reference. It is pleaded that by demand letter, demand of equal pay and facilities like regular employees has been made. Further pleaded that the workmen have been paid up to 31/3/2009 and their salary after that period is due. All the workmen are entitled for regularization in the light of the judgment of the Honorable Supreme Court and they have been working for more than 10 years. It is also pleaded that the 5 allied workmen are entitled for regularization, equal pay for equal work, and other facilities, and heirs of deceased workmen are entitled for areas and other facilities. The management in his written statement has pleaded that after the start of construction of work out of Ajay Barrage, the workmen were employed on need based on different dates between 1976 to 1988, and such employment was temporary and contractual, and payment of daily wages was being made to the workmen. The employment of the workmen was not against sanction post and required procedure such as advertisement, inviting application, sanction post, vacant post, qualification, seniority, reservation, etc. was not followed. In CWJC number 12448 of 1993, which was filed by some workmen, the Honorable Patna High Court has passed direction to take decision whether the workmen would be regularized or not. In the light of that judgment, Water Resource Department Bihar by letter number 07 dated 1/4/1995 issued order to terminate services of workmen employed after giving them notice in view of section 25F of the Industrial Disputes Act. Due to decrease in workload, the construction work of the Ajay Barrage was stopped and therefore the workmen were required no more and as such their services were terminated from 1/2/1996 after payment of compensation and 1 month advance salary. It is further pleaded that after getting letter of termination, some workmen moved to Honorable Patna High Court in the CWJC number 1225 of 1995, in which no relief was granted to the workmen, and it was only observed that if the project work was again started and the state government failed to make appointment on daily wages, then it might consider to employ the workmen. Against the judgment, LPA number 1251 of 1998 was filed, but again the Honorable Court refused to grant any relief to the workmen. In the year 1998, when the construction work of Ajay Barrage restarted, then in the light of previous judgment of the Honorable Court as well as agreement of workmen with Ajay Coordination Committee, these workmen along with others were employed in between the year 1999 to 2000 on daily wages basis, and payment was made to them from 31/3/2009. No work is being taken from the workmen due to decrease in work after end of construction work of Ajay Barrage. The workmen were employed in the light of judgment of the Honorable Court till the construction of Ajay Barrage, and after completion of construction work, services of these workmen is no more required, and all matters of regularization of these workmen is not pending before the government. It is also pleaded that the compensation regarding acquisition of land for the Ajay barrage has already been paid, so the demand of a regularization of the workmen is not proper. The point of adjudication here is in the terms of reference is that
An argument of the workmen and the management. And then where is the finding?
the finding is that
It starts from page number 20. These are all discussions with the management. With the para 23 and 23 separate. Page 45.
order passed by the Honorable High Court of Jharkhand in WPS number 700 of 2009 has been filed on behalf of the workmen, in which the Honorable Court has been pleased to direct the respondents to make payment to the petitioner who was daily wage worker. It was worker wages equal to the salary at the lowest rate of the employees of this cadre in Water Resource Department, State of Jharkhand. There cannot be any dispute that post in any administrative government department is created and sanctioned by the state government by following some process, and it is notified about number of posts to sanction, nature of post as to whether it is permanent or temporary or contractual or daily wages. There is no material on the record that post was sanctioned by the state government in construction of Ajay barrage, and it was vacant, and the workmen of this case were posted on that sanctioned post, which was vacant at the time of their employment. The workmen have claimed to have employed on the vacant post, but if post was not sanctioned by the state government, there cannot be any question of vacant post. Although the appointment letter of the workmen has not been brought on record either by the workmen or the management to show whether they were employed on the ground of acquisition of their land in the construction of Ajay barrage at Sakatia or otherwise, but it is admitted fact that they were employed in the construction of said barrage. The project of construction of any barrage has a life of a fixed period or limited period, and the workmen must be aware of this fact. Therefore, they cannot claim regularization of their service as a matter of right. It is not the case of management that the workmen were part-timers. On the contrary, there is material on the record that they work full-time allied to regular employees. Therefore, in the light of judgment of the Honorable Supreme Court in Jagjeet Singh Sutra, the workmen are entitled for wages at the minimum of the pay scale at the lowest rate on the regular pay scale extended to the regular employee holding the same post. The learned AGT contended that as no work has been taken from the workmen after 31/3/2009, so no payment has been made to them from 1/4/2009. In this regard, it is worth to note here that in the first part of employment, the workmen were removed from service after order and notice from competent authority, but no such order or notice has been brought on record by the management terminating the service of the workman. It further appears that the payment till the period 31/3/2009 has been made to the workmen in the month of July or August 2012. The workmen have examined themselves as witnesses and deposed that they are still working even after 31/3/2009, but such evidence is denied by the witnesses examined on behalf of the management, and there is no documentary evidence to support the oral evidence of the workmen witnesses that the workmen.
What else do you want to say? What else do you want?
So, as per the regarding the definition of the industry, that whether also that has not been taken as a ground in the before the learned labor code that a department is whether the department comes under the definition of the industry or not. But since this is a legal issue, it can be raised. So, may I read Section
Regulation of industry.
2J, my lord. My lord. Industry means any business, trade, undertaking, manufacture, or calling of employees, and includes any service, employment, handicraft, or industrial occupation, or avocation of workmen. So none of these things has been done by the government department. Government department is a sovereign, is doing the sovereign function. They are doing for the public service. They are not profit earning entity. Department is not a profit earning entity. So it comes under definition is a sovereign under sovereign function. So it is the department has not come under the definition of industry. As per
Which is
the
judgment of the Supreme Court is
Malod. The Supreme Court and not the judgment, but in one the judgment has been said that department the government is not doing the any
आपके ऐसा बोलने से हम ऑर्डर नहीं लिख देंगे.
no
हरी लंच में क्या किया? जजमेंट नहीं देते हम तो पाएंगे. हम क्या किया?
I got that judgment. Those judgments have been referred in these judgments. The reference of that judgment was there in the judgment passed by the Honorable Division Bench. It's reported in 2014 SEC online Jharkhand 2907. Ranjit Kumar Srivastava is State of Jharkhand.
Which particular citation are you referring to in this document?
This Manchu Kumar Vidyarthi, State of Bihar, 1997, Volume 4, SEC 391.
Yes, respondent. You were claiming regularization against sanction briefing post of the government.
Yes.
What do you have to say?
May I just read the concluding portion of the order, Honors, para 25. What has been given and what has been written. Internal page 27 of the award, running page 46 of my brief. Running page 46, internal page 27. Para 25 starts 2 lines, but just above that one paragraph I want to place. The management, it starts for. The management has not disputed the fact that workmen have worked for a continuous period of more than 10 years. It is unrefuted evidence of WW2 that in the second part of their employment they were employed in the month of March 1999, and the management has at least admitted that all the workmen worked till 31st 2009. As per Exhibit W12, at earlier occasions, services of some daily rated employees have been regularized. The learned counsel for the workmen has also contended that services of the similarly situated persons have been regularized. So the workmen of this case are at least entitled for consideration for their cases for regularization of their services. Now 25. In the light of above discussion, the reference is answered in the following terms. The workmen named in Annex A of the reference are not entitled to due wages after 31st 2009, but they are entitled for wages at the minimum of the pay scale at the lowest grade in the regular pay scale extended to regular employees holding the same post. They are also entitled for compensation to the tune of rupees 1 lakh for removing them without notice and following procedure under section 25F of IDA. Any payment to be made to workman Hemla Kisku may be made to his legal heirs, although the workman cannot claim for regularization of their services as a matter of right, but their claim must be considered by the management if cases of similarly situated persons have been considered and their services have been regularized. All such exercise should be done at the earliest dated copy of the. Only this much has been given to me, no straightway regularization. Direction is to consider if others have been considered, you consider them also for regularization, and at the same time, the tribunal has denied me that he is not entitled to due wages after so and so date, but before that, not at the lowest grade pay he is entitled to. So this much the only gap. And
1
this
lakh compensation also if you want.
is 1 lakh.
25F is applicable. 25F will be applicable only if they are governed by industry.
If they are governed by
Industry business.
that point I am answering. So this much is the only thing which has been given. Now the point has been raised that this is not an industry. This is not an industry. He has relied upon many judgments. I am coming straight to that. Now kindly come to the judgment. Recent one, 13 June 2024, WPL 6857 of 2016. I want to place every paragraph of this. If at all he has a case on this point. Now just place this. Learned Additional Advocate General, Mrs. So along with so. He submits that in spite of service of notice, respondent has not entered appearance. This writ petition has been filed under 22(7) of the Constitution of India seeking quashing of award dated 24/1/2024. Here is the difference. Here is the difference. Just let me point out. This petition is an application under Article 226 of the Constitution of India. Here it was 227 of the Constitution of India. The difference just I will point out in seriatim. Labor Code Devghar in reference number so and so, whereby the order of termination of the concerned workmen has been held to be illegal, and it has been held that they are entitled for regularization, compensation of service, and payment of their wages. Everything was given to those persons with compensation with reasonable time. Learned Counsel for the petition submits that the sole point involved in the present case is as to whether the Water Resources Department of Government of Jharkhand is an industry or not. The Learned Counsel has relied upon the judgment passed by the Honorable Supreme Court in the case of reported in so-and-so, para 5, to submit that in a case where a dispute raises as to whether a particular establishment or part of it is an industry or not, it would be the person concerned who claims the same to be an industry to give positive facts for coming to the conclusion that it constitutes an industry. It has also been held that ordinarily a department of government cannot be held to be an industry, rather it is a part of the sovereign function. Now, Counsel for the petitioner submit that a specific plea was raised by the petitioners before the learned Labour Court that the Water Resources Department of the state of Jharkhand is not an industry. Here I pause for a minute. Whether this point was ever raised before the learned Labour Court, rightly it fell from your ladyship that have you raised this plea. Entire records are here. The written statement filed by the state is here. I have the copy thereof. I have read the whole. Not a single event or even remotely it is not raised that this is not an industry. Whereas in that case, it was specifically raised that this is not an industry. Once this point is raised that this is not an industry, then burden lies on me, the workman, to prove by a positive evidence that yes, it is an industry. When the point was not raised, where is the question of reverting the same? Entire evidence is not here, the written statement of the state, it was not. So this judgment is not to be applied in the present case is my submission. But the learned labor court did not frame any issue in that regard. जब आप वहां रेज ही नहीं किए तो इशू कैसे रेज करेगा? In that case issue was raised, but the learned labor court did not frame the issue. Here the point is that when you did not raise the issue, where is the question of framing the issue on that point? And that regard, and has simply decided the case by stating that petitioners themselves had stated that they had followed the procedure under section 25F of the Industrial Dispute Act 1947, meaning thereby they are admitting that the department is an industry. Learned Counsel submits that once a point was raised by the petitioners that the department is not an industry, it was for the workmen to lead the evidence and bring on record this fact. So again I am saying that this is not there in my case. These aspects of the matter have been considered by the learned labor court. Learned counsel have also relied upon the judgment in the case of so-and-so versus so-and-so and submitted that aforesaid judgment passed by the Honorable Supreme Court has been followed in the said judgment and definitely, and definition of industry has also been considered, which specifically exclude any activity of the government relatable to the sovereign function of the state. After hearing, now the finding comes from the court. After hearing the learned counsel for the petitioners, this court finds that Honorable Supreme Court in the judgment reported in so-and-so has clearly held that if a dispute raises as to whether a particular establishment or part of it where in the appointment has been made is an industry or not, it would be the person concerned who claims the same to be an industry to give positive. Same thing, this dispute was not there. So now para 5 is quoted, here also the same thing, if I can read it. If a dispute raises as to whether a particular establishment or part of wherein the appointment has been made is an industry or not, it would be for person concerned who claims to same an industry to give positive facts for coming to the conclusion that it constitutes an industry. Ordinarily, a department of government cannot be held to be an industry, and rather it is a part of the sovereign function to find out whether the respondent in the writ petition had made any assertion that with regard to the duty which he was discharging and with regard to the activities of the organization where he had been recruited, we find that there has not been an iota of assertion to that effect, though no doubt it has been contended that the order of dismissal is initiated for non-compliance of section 25F of the Act. The state in its counter affidavit on the other hand refuted the assertion of the respondent in the petition and took the positive stand that the forest department cannot be held to be an industry, so that the provision of section 25F of the Act cannot have any application. In the absence of any assertion by the petitioner in the petition indicating the nature of duty discharged by the petitioner as well as the job of establishment where he had been recruited, the High Court only erred in law in applying the principles in so and so. This court further finds that before the learned labor court, the petitioners had specifically inter alia raised the following issue: whether the division where the workmen were engaged, that is irrigation department Sikatia, is an industry as defined under section 2J of the Act. Because this issue was never raised in my case. I have the written statement of the department. This court finds that the petitioners had specifically raised an issue. Because here lies the point. Again, it is being that specifically raised an issue as to whether the division where the workmen were working is an industry. So this issue was raised and the London Labour Court did not answer, therefore the lawsuits interfered with that. In my case, this is not there. The department has never raised this issue. From the records, if I am permitted, I want to place the written statement of the department. The Labour Court record has come.
What is the nature of reference over here?
Reference. Nature of reference is it is notes on the first page of award itself, Annexure 1, page 22.0. Whether non-payment of due wages and regularization of services of Sri रंजू हेम्ब्रम, सबका नाम है, ऑल चौकीदार, by the management employer, executive engineer, water resources department, secretariat Devghar, and others is justified. If not, what relief they are entitled to. And this reference is at the instance of the Department of Labour, Employment and Training, Government of Jharkhand. My contention is that you cannot challenge the reference right now. In fact, you are challenging the reference, that this reference is bad. Labour court was not competent to decide this issue because the department is not an industry. It is you. I repeat this because it is the state of Jharkhand which is the appropriate government under the act, and the state of Jharkhand has referred this matter to the Labour Tribunal. And now you cannot be permitted to turn around, take completely U-turn, merely because the workmen did not appear in the writ petition. The workmen did not argue before this honorable court. Therefore, this judgment and this judgment is not binding on this court, not as far as my case is concerned. The department itself has referred this matter to the tribunal, to the Labour Court, under section 10(1)(c). That my lords will find from the first page of FR. The present case has been initiated on the basis of notification of the Department of Labour, Employment and Training, Government of Jharkhand under section 10(1)(c) of the Industrial Dispute Act. Now you will say that no, it is not an industry. You are changing your stand, that too after 10 years. 2013 is the reference. If the reference was bad, the petitioner should have challenged the reference. The reference is bad. So this point is not available, at least to the present petitioner of this writ petition. Moreover, the entire evidence is there. If your lordship will permit, I can read the whole award. Everything was considered, the documents were examined, the witnesses were examined, and then finally a finding has been returned that yes, these persons are entitled for regularization, for the minimum wages.
They are to be considered for regular employment under whom?
It has been
Under
directed.
sanctioned post.
It has been directed that you should consider.
Against what? Considered for regularization against what?
Against the post of Chowkidar on which they were working.
Regular sanctioned
Sanction है कि नहीं, it is not the case. I don't find anywhere in the writ petition
direction.
that he was not working against the sanction post. कहाँ है writ petition में तुमको नहीं कहीं मिला ये?
Similarly situated persons.
Similarly situated को अगर regulation हुआ है, then you regularize. Consider his regulation.
The workmen named, देखिए para 25 में are not employed and are not entitled of due wages after 31/3/2009.
Yes.
But they are entitled for wages at minimum pay in the pay scale at the lowest grade in the regular pay scale.
Yes.
Extended to regular employees holding the
Yes. If he has discharged the duty, then he should be paid the minimum pay scale of a regular employee. This is the order. That reference my lords will find in Jagjit Singh case decided by Justice Kheher in 2017.
that was in public employment, specifically relating to public.
Public employment ही तो है. This is purely public employment. The state is there. A state has taken the work from me. I mean for construction of this barrage. Purely industrial work, if I may say so. It is a construction of barrage. It is not that in the office I was working, therefore it is not an industry. It is a construction of barrage. Purely industrial work was going on, where I was posted as a chowkidar. And these things were not argued before my lord, therefore this order came. Now, moreover, I would again rely upon which I argued before my lords earlier, that Surdev Rai judgment, famous case on this issue, how the power under 226 or 227 for the sake of certiorari can be exercised. I had argued this matter. I have that judgment also which was delivered by my lords. But before that, I want to refer the Suryadev Rhinos 2003 6 SCC page 675. 2003 6 SCC 675. Notes in earlier case notices were served upon them. These poor persons did not appear before the Supreme Court, and therefore these things could not be brought to my lord's notice. Because para 38 I would rely upon.
What thing cannot be brought to
My lord, my lord,
Which earlier case? You were
the judgment which my friend is relying upon, delivered by your ladyship, in that case Workmen did not appear. No argument from the other side. It's ex parte decision, but after serving the notice.
ex parte decision is also binding on the concerned parties. How are you concerned with that? We are concerned with the records of your case.
No, my friend is citing that judgment. I want to distinguish this judgment by saying that these arguments could not be advanced in that case. So that judgment is not binding on this court for the purpose of this case. Is my humble submission.
Labor matter, every case has its own record.
Yes, that is what I am saying.
We are not concerned with that.
And nurse, I am not required to cite a judgment.
We are confronted with the situation that arising out of the same project, there is a direct judgment of this court that it is not an industry.
Not in an industry.
Yes.
For the reason that this point was raised and the court did not decide, therefore.
No. There is another judgment of division bench. It's the same department. Different
Well, the Justice
There
Mukhopadhyay.
is your Justice Mukhopadhyay's judgment.
It's a
Directly
same
on the
department.
point, with the same department. It is in connection with the same department. And this Siktiya only.
Yes.
Yes.
I can read this judgment also. I have read this.
So tell us, this is in connection with the same area, same place.
May I read this judgment then? Before I cite other judgments, may I just place this?
And apart from that, for an industrial adjudication, there is for claiming regularization, there has to be 240 days of continuous work. Where is the evidence of that?
यहाँ तो 10 years का है.
10 years continuous कहाँ से क्या है material 10 years के लिए? What material that you have been continuously working on?
I can read from the award. I can read from the award only.
Just let us have a look at this judgment.
First,
It is in connection with the same same place. Is it from the same place?
Yes, ma'am.
may I just place this? This writ petition has been preferred by the petitioner state of Jharkhand against the
आपने
award.
पढ़ा होगा ना अब आप सीधे relevant हो.
हम पूरा पढ़े हैं और हम ये कहना चाहते हैं कि this judgment is not at all applicable to my case. And for that purpose, unless and until I read this notes, it would not be in my notes evident that, because there were other issues on which the court was weighed by these things, and therefore the interference was there.
You come to para number 8.
Para 8.
Para 7 and 8.
Para 7. From the facts pleaded by the parties, as appears from the award, it would be evident that the workman respondent was not appointed on regular basis. He was not a regular employee against any post. No procedure was followed at the time of engagement on daily wages in the irrigation division Deoghar. From the award, it would be evident that there is no finding given by the presiding officer that the division where the workman was engaged, that is irrigation division Deoghar, is an industry as defined in the section so and so. From the award, it will be evident that the workman claimed to have worked between 1982 and 82 to May 1985, as mentioned at paragraph 4 and 19 of the award. On the other hand, from paragraph 19 onward, it appears that workmen claimed to have been appointed on 1st January 1981. The presiding officer Labour Court Deoghar failed to notice the number of days the workmen actually performed duty in a calendar year. On other hand, calendar month was presumed from March 1982 to February 1983. Entirely different facts, not from my case are not like this, 240 days, etc. And from March 83 to February 1984, which is not in consonance with section 25B of the IBI. Even it was not properly determined whether the workmen completed 240 days of continuous service in one or the other calendar year or not. There is no finding on the record that the workmen completed 240 days of continuous service in preceding calendar year. Therefore, interpreted. It is not in dispute that the workman was disengaged since August 1985, but no order of termination was issued. Malos, kindly mark the difference. 82 is the appointment, and he did not work after 1st August 1985.
3 years हो ही गया था.
Yes.
20 साल हो चुका.
Yes. But no order of termination was issued. In absence of finding relating to the exact period of service rendered by the workman, the award cannot be held to be complete. Similar issue fell for consideration before the bench of Jharkhand High Court in the case of so-and-so versus so-and-so. On the basis of the policy decision of the state government, daily wages workers engaged after 1st August 1985 were disengaged. This court, having noticed that the workmen were engaged without any advertisement, without any interview, and no letter of appointment termination having been issued, held that those daily wages workers had no right to post, and the concept of retrenchment cannot be stretched to cover such workmen. The present workman is similar situated and covered by decision of this court in the case of management of so-and-so versus so-and-so. In the case of a state of Bihar versus so-and-so reported in so-and-so, the Supreme Court, having noticed similar facts, held as follows. The admitted position is that the petitioner 1 came to be appointed as assistant, petitioner 2 as driver. No, the facts of that case is there. Whether the petitioners can be said to have been rendered retrenched within the meaning of section 25F of the Industrial Dispute Act, every department of the government cannot be treated to the industry. Well, it's true. Every department and situation is also different. My matter relates to construction of a barrage where I was posted. When the appointments are regulated by the statutory rules, the consent of industry to the extent stands excluded. Admittedly, they were not appointed to the post in accordance with the rules, but were engaged on the basis of need of work. They are temporary employees working on daily wages. Under these circumstances, their engagement from service cannot be construed to be retrenchment under the Industrial Disputes Act. The concept of retrenchment therefore cannot be stretched to such an extent as to cover the employees. The learned counsel for the petitioner seeks to contend that in the High Court, the petitioners did not contend that it is a case of retrenchment, but termination of their service is arbitrary. Since they are not only daily wages employees and have no right to post, their disengagement is not arbitrary. Admittedly, the workman was not appointed against any post. He was engaged on daily wages without any advertisement and without any interview. Therefore, the question of reinstatement of workmen on the same post with the same service condition and pay as recorded by the presiding officer cannot be implemented, which will otherwise amount to giving regular employment against a vacant post taking the course of section 25F. In these circumstances, the upon the now, kindly see the facts of my case. It is said that yes, regular post was not there, advertisement was not there, and therefore the court interfered. What is my case? My case is from the first page itself, the distinguishing features. Annexure 1, page 20. First page से just the workmen का case क्या है? Just I want to place. The workmen and management appeared and filed their respective written statement. The workman has asserted in the written statement that all the 6 workmen named in Annexure A of reference were employed with the permission of the department on the post of Chowkidar before construction of Sikatia Barrage against sanction in vacant post. The land of workmen was acquired. Kindly mark these things below, the distinguishing features. Advertisement, no advertisement. Our lands were required, therefore we were appointed. The land of workmen was acquired in Sikatia Barrage and they were provided employment being land loser, except Hemlal Kisku, who was employed on the ground of being a member of scheduled tribes. The workmen were removed from service for some period and due to movement of union, they were taken back on duty from March 99 and they were working since then except Hemlal Kisku, who died before the reference. It is pleaded that by demand letter, equal pay and equal facilities like regular employees has been made. Further pleaded that the workmen have been paid up to so and so and their salary after that period is due. All the workmen are entitled for regularization in the light of the judgment of the Honorable Supreme Court as they have worked for more than 10 years. So advertisement or no advertisement, this question is not there. And you have to controvert that yes, he was not working against sanction post or advertisement was not there, or you have to say that no, land was not acquired of these persons. You acquired our land, therefore you provided the employment to us. These are the distinguishing features from those cases. Is my humble submission before my lords. Now, lords, the record is here. If my lords will just turn to the written statement filed by the management. The caption is कामगार जिनके प्रतिनिधि हैं सिंचाई कामगार यूनियन मुख्य अभियंता जल संसाधन परिषद देवघर के संबंध में तथ्यात्मक विवरण। वही रेफरेंस केस नंबर 1 ऑफ 2020। इस केस में जो इनका WS है बिफोर द लेबर कोर्ट, और इफ आई कैन गेट द रिकॉर्ड आई कैन पॉइंट इट आउट। मैं जस्ट प्लीज सिंचाई कामगार यूनियन मुख्य अभियंता परिषद देवघर के अध्यक्ष श्री संसद द्वारा मांग के आधार पर जयसवाल इतना प्रसाद बहाल किया गया। उपयुक्त दावों आरोपों तथा मांगों के संबंध में कहना है कि अब इनका क्या स्टैंड है। सुबान अजय बराज का निर्माण कार्य प्रारंभ होने पर कार्य की आवश्यकता को देखते हुए इन कामगारों को वर्ष 76 से 88 के बीच विभिन्न तिथियों को काम पर रखा गया। इन कामगारों का नियोजन पूर्णतः अस्थायी एवं औपबंधिक था। सो इफेक्ट है कि 76 से लेकर 88 तक हमसे काम लिया। इट इज द केस ऑफ मैनेजमेंट, नॉट माय केस। इन कामगारों हाँ कार्य की आवश्यकता को देखते हुए इन कामगारों को बस हाँ रिक्वायरमेंट था तभी हम लोग करोगे। दूसरा, इन कामगारों को कार्य करने के एवज में दैनिक मजदूरी का भुगतान नियमानुसार किया जाता था। तीसरा ग्राउंड है तत्कालीन कामगारों का नियोजन पूर्ण रूप से औपबंधिक एवं अस्थायी होने के कारण आवश्यकतानुसार कामगारों की संख्या घटाई एवं बढ़ाई भी जाती थी। इन कामगारों का नियोजन किसी भी स्वीकृत बल के विरुद्ध नहीं किया गया था। साथ ही नियोजन हेतु वांछित प्रक्रियाएं यथा विज्ञापन आवेदन संग्रह स्वीकृत पद रिक्ति योग्यता वरीयता आरक्षण आदि का पालन भी नहीं किया गया था। इस प्रकार इनका नियोजन संवैधानिक नियोजन नहीं था। कतिपय कामगारों द्वारा माननीय उच्च न्यायालय पटना में इतना विनियमित किया जा सकता है अथवा नहीं, इस बिंदु पर निर्णय लिया जाए। इस निर्णय के आलोक में जल संसाधन बिहार के अधिनियम की इतना उपर्युक्त आदेश में यह भी उल्लेखित है जल संसाधन विभाग के काम में अप्रत्याशित रूप से कमी होने के कारण विभाग के स्थापना बल में कटौती करने की नितांत आवश्यकता हो गई है। कार्यभार में कमी आने की परिस्थिति में अजय बराज का निर्माण कार्य बंद हो गया और इन कामगारों की सेवा की आवश्यकता नहीं रह गई। फलस्वरूप उपर्युक्त क्रमांक 5 में वर्णित
द्वारा पत्रांक 7 दिनांक 1/4/95 के माध्यम से आदेश निर्मित किया गया कि कार्यरत कामगारों को औद्योगिक विवाद अधिनियम की धारा 25F के आलोक में
नोटिस देते हुए कि सेवा की समाप्ति करें। अब ये खुद एडमिट कर रहे हैं कि इंडस्ट्रियल डिस्प्यूट एक्ट अप्लाई करता है, इसलिए 25F को फॉलो करिए। दिस गोज अगेंस्ट द पिटिशनर इज माय हम्बल सबमिशन सब्जेक्ट टू व्हाट माय लॉर्ड। यस, कार्यभार में कमी आने की परिस्थिति में अजय बराज का निर्माण कार्य बंद हो गया और इन कामगारों की सेवा की आवश्यकता भी नहीं रही। फलस्वरूप प्रयुक्त क्रमांक इतना में वर्णित विभागीय आदेश के आलोक में कार्यालय अभियंता सिकटिया द्वारा वर्ष 1995 में इन कामगारों को औद्योगिक विवाद अधिनियम की धारा इतना के तहत नोटिस दिया गया। अगेन द सेम थिंग, यू सेड दैट यस आईडी एक्ट इज एप्लीकेबल। अभिलेखों से और कहते हैं कि भुगतान भी कर दिया गया 25F का फॉलो करके। अभिलेखों से यह भी स्पष्ट होता है कि काम से हटाने संबंधी नोटिस प्राप्त होने पर कतिपय कामगारों द्वारा माननीय न्यायालय पटना में इतना कार्य विचार करती है तो इन पर निर्णय लिया जाएगा। LPA का वर्णन है। फिर 8 पैराग्राफ 8 में वर्ष 1998 में बराज निर्माण का कार्य पूर्ण शुरू होने पर पुनः शुरू होने पर माननीय उच्च न्यायालय के पूर्व आदेश एवं अजय समन्वय समिति के साथ हुए समझौते के आलेख में इन कामगारों को अन्य कामगारों के साथ ही वर्ष 99 से 2000 के बीच दैनिक मजदूरी के रूप में रख लिया गया और इन्हें निर्धारित दरों पर मजदूरी का भुगतान किया जाने लगा। 31/3/2009 के बाद इनसे काम लेना बंद कर दिया गया क्योंकि अजय बराज का निर्माण समाप्त होने के बाद कार्य की मात्रा में काफी कमी आ चुकी थी। उल्लेखनीय है कि इन दैनिक मजदूरों की विधिवत नियमित बहाली नहीं की गई थी, इस कारण उन्हें हटाने हेतु कोई प्रक्रिया नहीं अपनाई गई। इस प्रकार 31/3/2009 के बाद से इन कामगारों से काम नहीं लिया। दिनांक इतना को विभाग द्वारा अवर सचिव झारखंड रांची विधानसभा को भेजे एक ध्यानाकर्षण सूचना के जवाब में कहा गया कि अजय बराज के निमित्त अधिग्रहित भूमि के मुआवजे की राशि की अदायगी कर दी गई है और इन कामगारों को माननीय उच्च न्यायालय पटना के निर्देश पर बराज निर्माण अवधि तक के लिए ही रखा गया है। निर्माण कार्य समाप्त होने के बाद इनकी सेवा की आवश्यकता नहीं है। ये राज्य सरकार द्वारा उपर्युक्त तथ्यों से स्पष्ट है कि प्रसंगाधीन मांग पत्र में किए गए दावे में लगाए और अब सत्य नहीं है था। ये कामगार किसी तरह के कहीं भी ये पॉइंट नहीं लिया हुआ है कि इंडस्ट्री नहीं है, इसलिए आई कैन रीड सम मोर पैराग्राफ। यहाँ उल्लेख करना है कि प्रासंगिक पत्रों जिस व्यक्ति का चयन व्यक्ति इतना मांग पत्र पर बिंदुवार उत्तर। इन कामगारों के अभी भी कार्यरत रहने के दावे में कहना है कि इतना के बाद से सिंचाई नहीं है। इन खाली पदों पर बहाल किए जाने बारे में कहना है कि इन्हें नियमित बहाली की प्रक्रिया अपनाए बगैर दैनिक मजदूरी के रूप में काम पर लगाया गया था। इन्हें गलत ढंग से हटाए जाने संबंधी दावे का खंडन किया जाता है। इन्हें आंदोलन के बाद पुनः काम पर रखे जाने संबंधी दावों का कहना है कि यह आरोप सत्य नहीं है। इन्हें बजाज समन्वय समिति के साथ समझौते भविष्य में इन कामगारों को प्रबंधन आवश्यकता रहने। सो नेवर दिस पॉइंट इज रेज कि इंडस्ट्री है कि नहीं, और वो केस ही पूरा बेस्ड है उसी पर। दैट पॉइंट वाज रेज, द ट्रिब्यूनल डिड नॉट डिसाइड, देयरफॉर द ऑर्डर इज परवर्स एंड इट्स सेट असाइड।
रेफरेंस कब का?
13 का 2013 डेट इज माइनस ऑन द फर्स्ट पेज ऑफ अवार्ड 14/6/2013।
डिस्प्यूट का बेस
It must be after 2009, after they were
31/3/2009.
compelled not to take work.
कितने गवाही? How many evidences?
How many
How many witnesses?
witnesses? There are 5 witnesses
Management 5.
on behalf of the.
Management 5.
It is at page 3, internal page 3.
5 witness from both the sides.
ये वर्कमैन का एविडेंस कौन है? मैनेजमेंट का एविडेंस है वर्कमैन।
मैनेजमेंट का एविडेंस है इंटरनल पेज 4 पर। पहला हृदय नारायण सिंह, दूसरा जयदेव प्रसाद सिंह, मोहन सिंह, रंजो हेम्ब्रम एंड मंगल सिंह।
Manoj,
Where is it written that?
from the judgment itself,
Page 3
page
पर
number
है.
22, internal page 3. Of the award.
This was filed on 23/2014, right? पेज नंबर कौन सा बताया?
Page number 22, Manoj, internal page 3. Of the award, Manoj. Paragraph 5, Manoj.
Oral evidence. And the discussion of their oral evidence starts from para number 9. Right?
Yes, Manoj. And management request from para 11.
आधा ही आया है. हाँ, पढ़िए.
Manoj,
You read para 9.
para 9. I have heard the learned counsel for the party and tell you the case report. Firstly, I would like to discuss the evidence and materials on the record. Workman witness 1, Hidden Naran Singh, who is one of the workmen, has stated in his examination in chief on affidavit that all the workmen of this case were employed as bochotira from the time of construction of Sikatiya barrage on the basis of qualification on vacant post, and the nature of work was permanent, and they have been working on the post which is permanent in nature. All the workmen except Himlal Kistu were employed on the basis of being land user, and Himlal Kistu was employed on the ground of being a member of scheduled tribe. Their land was acquired for construction of Sikatiya barrage on the condition that one person in every displaced family shall be provided government job, but in spite of rendering service for a very long period, their service has not been regularized. He has further stated that all the workmen were removed from service for some days, but due to agitation of union and others, they have been taken back on their work in the month of March 1999. And since then they are working. He has further deposed that the superintending engineer Madhupur Central has admitted in his letter number 1063 dated 18/9/2006 that 25 workers are needed and the post is vacant and all the workmen are employed against the vacant post. He has further stated that the workmen have been paid till 31/3/2009 and their salary is due since then. He has stated that all the workmen are entitled for regularization and they have rendered service more than 10 years. He has further stated that earlier the workmen have been paid equal pay for equal work by the order of Honorable High Court. In this cross-examination, he has said that the chief engineer had a camp at Sikatiya for employment of person whose land was acquired for barrage, and he was appointed by the chief engineer in the year 1986. He was further stated that appointment letter was not given to him, and he was employed on the basis of oral consensus between the chief engineer and the villagers. He has further deposed that the paper of such a consensus was prepared for employment of 25% and their name and address were noted in and its copy of each of the candidates was supplied. In paragraph 13, he has deposed that he was given an appointment letter signed by the chief engineer, while earlier in paragraph 3 of the cross-examination, he has said that no appointment letter was issued to him. He has further deposed that the workmen have been removed and they are still working and making their attendance, but payment has been stopped since 2009. He has denied suggestion of the management that no work is required in the department, so the workmen have been removed from service after payment of 1 month wages. The workman witness to Jaidev Prasad Singh, who is another workman, has stated in his examination in chief on affidavit in the same manner as stated by the workman witness number 1, except the details of his land acquired in the construction of the barrage, and also that he was appointed on 21/12/1985 at Chautidar. In his cross-examination, he has said that there was 25 posts vacant in Sikatiya Barrage Irrigation Division, but such vacancy was not published in the newspaper and later was issued to employ those persons whose land was acquired, and the chief engineer appointed 25 persons on those 25 vacant posts. He has further deposed that 500 persons came for appointment, out of which 25 persons were appointed and they all got appointment letters. He has admitted that he has not filed his appointment letter in the court and said that the appointment letter is not with him, but later on said that he has filed his appointment letter through his lawyer. He has further said that it was written in the appointment letter that he was being appointed in his land as his land has been acquired. Witness number 3, Mohanlal Singh, who is another workman employed as Chautidar watchman, has stated in his examination chief on affidavit exactly in the same manner as stated by the witness 1 and witness 2, except that he was appointed on 21/12/1985 as Chautidar. In his cross-examination, he has said that the government has paid compensation to landowners after acquisition of their land. He has deposed that he has started working in Ajay Barrage.
That's right, I've seen the evidence. Can you tell us where is the finding regarding the period of work in the award? Which paragraph gives a finding with regard to the period of work? Which is that paragraph, Mr. Kandan? That finding must have been arrived at that they were working for 10 years, 5 years,
Para 13.
15 years.
Para 13.
Para?
13 page, internal page 13, page number 32 of the report.
Page number.
The workmen have claimed regulation of their service in the light of judgment of Honorable Supreme Court on the ground that they have continuously worked for more
This
than
is
10
the
years.
ground. Where is the finding that they have worked for continuously 10 years? Or what was the period for which they have worked?
That has not come.
Please don't say like this. Be very sure. The respondent will tell us where is that finding of the court as to what is the period for which they have worked. Forget about the continuous period of work. They were working for 10 continuous years on the basis of Uma Devi, straight away an order of regularization could have been passed. But no such order has been passed. So I just want to know what is the finding with regard to the period of work.
Page 46 running, internal page 27. Last but one, which I read initially. The management has not disputed the
How
fact
this admission of fact is coming?
that the workmen have worked for
Continuously from where this admission? Which is the evidence for this
admission है ना, WS में है admission.
WS में admission.
हाँ,
Continuously
हम पर-
काम कर रहे हैं.
WS में एडमिशन क्या है कि अजय बराज का निर्माण कार्य प्रारंभ होने पर कार्य की आवश्यकता को देखते हुए इन कामगारों को वर्ष 1976 से
76.
1976 से 1988 के बीच विभिन्न तिथियों को काम पर रखा गया। इन कामगारों का नियोजन पूर्ण रूपेण अस्थायी। सो दी मैनेजमेंट एडमिट्स की 76-88 तक काम किया है।
इसमें तो फाइंडिंग दूसरा है ना, for continuous period of more than 10 years, which is unrepeated evidence of WWs. That is
इसीलिए फाइंडिंग आया
that they were employed in the month of March 99, and the management had at least admitted that they were working till 31/3/2009.
यस। तो उसके बाद में 88 के बाद में जब हटा दिया तो फिर से इनको वापस ले लिया और फिर काम इन लोगों से कराया।
88 के बाद फिर मार्च 99 में।
यस। इतना एडमिटेड है कि 10 साल ये लोग काम किया है। एंड दैट इज व्हाट द फाइंडिंग हैज बीन रिकॉर्डेड बाय द लर्नेड ट्रिब्यूनल। दे डोंट डिस्प्यूट दिस। और सारा जजमेंट को कंसीडर करके इफ माय लॉर्ड्स विल permit me to place from paragraph number after the witnesses etc. discussion about this from page 13 onward. The tribunal has considered first Uma Devi, second the judgment in the case of ML Kesari, para 15, and then Narendra Nath Tiwari जो कि झारखंड से अराइज कर रहा है, para 16. Then on the point of equal pay for equal pay, which I was referring to, state of Punjab versus Jagjit Singh, 17(1) SCC. It says daily wager or whatever you have taken work, you have to pay the minimum pay scale, not with the increment and all, but minimum pay scale you must pay. Even to the daily wager. This is judgment of Jagjit Singh, 2017(1) SCC. This is considered at page 23 of the award. And the tribunal is very much conscious of its jurisdiction, and that is why much has not been given to the workmen. Very limited prayer of the workmen has been accepted by the tribunal. Very limited one. Pay the minimum and consider for regularization if others have been considered similarly situated. This judgment, the judgment on 227 is already that Surjadev Rai case, which I have just handed forwarded to the court master. Citation is notes 2000. I have flagged it. This judgment I want to place this. This is necessary. In what circumstance the writ court can interfere in the matter of certiorari? 226 years 5. 38. 38 का 1 हम स्किप कर जाते हैं, 2 भी स्किप कर जाते हैं, 3 से हम पढ़ते हैं। 31, 38 का 3. Certiorari under Article 226 of the Constitution is issued for correcting gross errors of jurisdiction. That is, when a subordinate court is found to have acted without jurisdiction by assuming jurisdiction where there exists none, or in excess of its jurisdiction by overstepping or crossing the limit of jurisdiction, or 3. Acting in flagrant disregard of law or the rule of procedure, or acting in violation of principles of natural justice where there is no procedure specified and thereby occasioning failure of justice. 4 is more important. Supervisory jurisdiction under Article, because it's a labor court. I am not raising technical plea that this is not under 227. It is in a specific term 226. But even 227, my lord said the power and jurisdiction, it says supervisory jurisdiction under Article 227 of the Constitution is exercised for keeping the subordinate courts within the bounds of their jurisdiction. When a subordinate court has assumed a jurisdiction which it does not have, or has failed to exercise a jurisdiction which it does have, or the jurisdiction though available is being exercised by the court in a manner not permitted by law, and failure of justice or grave injustice has occasioned, thereby the High Court may step in to exercise its supervisory jurisdiction, be it a writ of certiorari or the exercise of supervisory jurisdiction. None is available to correct mere error of fact or of law unless the following requirements are satisfied. Number 1, the error is manifest and apparent on the face of the proceedings, such as when it is based on clear ignorance or utter disregard of the provisions of law and a grave injustice or gross failure of justice has occasioned thereby. Notice, I would submit, relying upon this paragraph of the Apex Court, that none of these points are available to the petitioners. The petitioners have not even argued that there is manifest error apparent on the face of record, clear ignorance of law, utter disregard. Nothing is argued even by the petitioner. There is no pleading also in the writ petition. 6 says, a patent error, because it qualifies what is called a patent error. A patent error is an error which is self-evident, that is, which can be perceived or demonstrated without involving any lengthy or complicated argument or a long drawn process of reasoning, where two inferences are reasonably possible and the subordinate court has chosen to take one view, the error cannot be called gross apparent. 7 says, the power to issue a writ of certiorari and the supervisory jurisdiction are to be exercised sparingly and only in appropriate cases where the judicial conscience of the High Court dictates it to act lest a gross failure of justice or grave justice should occasion. Care, caution, and circumspection need to be exercised when any of the aforesaid two jurisdictions is sought to be invoked during the pendency of any suit. That may not be relevant for this. The High Court in exercise of certiorari or supervisory jurisdiction will not convert itself into a court of appeal. My friends wants ये चीज नहीं है, ये evidence तो ये, these things are not to be seen in a writ petition under 226. The tribunal has it's a well reasoned award in 27 running 27 pages. Every aspect, petitioner's case, respondent's case, evidence, etc. has been dealt with.
Seeking regularization, right?
Miles?
You were seeking regularization.
As also equal pay for equal work.
And also equal pay for work.
Yes.
It was never your case that you have been terminated. Was that your case?
ये भी केस है
That is not
कि हमसे काम नहीं लिया जा रहा है.
terms of reference.
2000
Terms of reference.
Yes. Terms of reference is whether non-payment of due wages and regularization, both of services of Sri so and so नाम है सबका executive water.
Terms of reference was not termination.
Others, हाँ ये नहीं है.
नहीं है ना? Finding 25 का.
हाँ ये है कि ड्यू वेजेस मिलना चाहिए कि नहीं, रेगुलराइज होना चाहिए कि नहीं.
का फाइंडिंग कैसे होगा when the terms of reference is not in terms of termination? That is not the terms of reference. The court cannot go beyond the terms of reference. The point was whether you are entitled for due wages or they were paying you due wages or not, and whether you are entitled for debt.
उतना ही तो गया ट्रिब्यूनल, उतना ही पर तो लेवल पर गया.
25F का कहानी कैसे हुआ?
25 का रेफरेंस है क्योंकि फैक्ट्स है which will lead to this conclusion. This is inbuilt. It is their case कि 25F को कंप्लाई करके हम इनको हटा दिए इसलिए रेगुलराइज नहीं करेंगे. It is their case कि इसके
they are entitled for compensation to the tune of ₹1 lakh for removing them without notice.
Yes.
Removal from without notice was not the terms of reference. That was nobody's case that you have been removed without notice. That was not the terms of reference. The terms of reference was that you were not getting due wages.
May I just repeat it? These are just the facts which will lead to this aspect. These are the facts.
But at the same time, the court goes beyond the terms of reference.
My submission is that when the court.
अब तो 226 का बात नहीं है ना. अब तो हम लोग को देखना है कि कोर्ट ने अपना काम ठीक से किया है. इतना ही बात देखना है. A labor court is bound by the terms of reference. And the labor court has to answer the reference only and nothing more.
Yes, but to answer the reference, what are the intermediate facts are?
You see, two things
required to be referred.
Have been denied to you. One is any wages after 2009.
Yes, that is what I said. That limited prayer of the workmen has been considered. In fact, this award should have been challenged by the workmen also before this court. That nothing has been given to me. What has been given?
So,
minimum pay scale and consideration for regularization.
आप हमको बस इतना बताइए, कोई भी जजमेंट देख के बताइए, ऐसे नहीं बताइए। ये जो टर्म्स ऑफ रेफरेंस है 25F का टर्मिनेशन इस टर्म्स ऑफ रेफरेंस के अंदर आ जाएगा, because the terms of reference is with regard to wages and regularization. The question of regularization arises only when a person is working, isn't it? If the person is discontinued, then that is a different cause of action and there is a termination, and qua 25F under the Industrial Disputes Act various parameters is required to be seen.
मेरा सबमिशन है ना कि the London Labour Court has just considered the reference only, and while giving the answer to the reference has referred these things.
That's it.
This is my point. Because unless the arbitrariness on the part of the respondents concerned are considered, कि how in what way they have now been discontinued, the learned tribunal may not come to this conclusion that yes, he is entitled for this. And not only this, the reference is something more also, and it is always there. If not, what relief they are entitled to. This is also there. And therefore the learned tribunal was bound to consider these aspects of the matter when it was pointed out to the tribunal that 25 was exercised, 25 of notice was given, this much amount was given. So these are just the considerations. But basically the tribunal has considered that since the workman has worked for more than 10 years, and this is not in dispute, and therefore they are entitled for regularization, as also the minimum wages which was there in the case of Jagdish Singh, page 42, if my notes will refer to just internal page 23. May I just place this, internal page 23, running 42.
Just that we have seen, we have placed it.
Regarding, हम इसको नहीं प्लेस किए हैं. Regarding principle of equal pay for equal work, in case of a state of Punjab and others versus Jagdish Singh and others reported in so and so, and Supreme Court has held that principle of equal pay for equal work has also been extended to temporary employees. Their case was that yes, they were temporary employees. Supreme Court says in paragraph 57, 58, 59, etc. that even daily workers are entitled for the minimum pay scale. And this judgment still holds good, is my humble submission before my lords.
Isn't it contradictory that on the one hand you give compensation for non-compliance of 25F and simultaneously you say that they are to be considered for regularization and placed at the minimum pay scale?
Because once it is held that you have removed these persons without complying 25F, once
What is the consequence?
once the tribunal holds so,
Provided there is a reference to that.
रेफरेंस तो बहुत क्लियर है.
That's all.
इन स्पेसिफिक टर्म इट सेज नोट्स, और इसीलिए एक लाइन और भी रहता है हर एक रेफरेंस में कि इफ नॉट देन फॉर व्हाट रिलीफ इज इंटाइटल्ड टू. स्पेसिफिक है कि नॉन पेमेंट ऑफ ड्यू वेजेस और रेगुलराइजेशन, जो दो चीज आप इनको डिनाई कर रहे हैं वो इनको मिलना चाहिए कि नहीं, एंड if what relief they are entitled to. So the tribunal, the labor court has confined to this aspect only, not beyond that, is my humble submission.
The issue that with the Department of Industry, and although that has not been taken in the learned labor code, but the question of law that can be raised at any issue, any point.
WPA number 1544 of 2024. For the this petition has been filed challenging the award dated 5th of November 2022, passed by the presiding officer in the reference case number 1 of 2023 report. Wherein the labor code is saying that the workmen are not entitled to due wages after 31/3/2009, but they are entitled for wages at the minimum pay scale extended to regular employees holding the same post. And the labor code has also held that the workmen are entitled for compensation to the tune of rupees 1 lakh per head without notice and without following the procedure under Section 25F of Industrial Disputes Act. The Learned Counsel appearing on behalf of the petitioner by assuming the ensuing award has submitted that the Learned Labour Court had no jurisdiction to decide the case in view of the fact that the petitioner in his Water Resources Department, Irrigation Division, Sitya Devghar, is state and was discharging sovereign functions. The Learned Counsel has submitted that though this point was not specifically raised, but it is a point of law, particularly in the light of the judgment passed by this court in 2006, within bracket 1 JLR 382, within bracket State of Jharkhand to Executive Engineer Irrigation Department versus Jwala Rao. Right, you have not raised this point before the court. The Learned Counsel has also relied upon the judgment passed by Division Bench of this court, reported in 2014 SCC Online JHR 2907. And has submitted that no material was produced on behalf of the concerned workmen to show that the activity of the petitioner was relating to any manufacturing or related activities. The Learned Counsel has also relied upon the judgment passed by this court in 2024 SCC Online JHR 3052 to submit that this court has framed the point of law and remanded the back for remanded the back to the concerned labour court for fresh consideration. The point of law was relating to, inverted comma, whether the division where the workmen were engaged, that is Irrigation Department Sitya, is an industry or not within the meaning of Industrial Disputes Act 1947. The Learned Counsel has also Counsel has submitted that the petitioner is not an industry and therefore the concerned labour court had no jurisdiction and consequently the improved award is to be set aside. It has also submitted that the Learned Court has gone beyond the terms of reference. छोटा तीनों जजमेंट हो गया The learned counsel appearing on behalf of the respondents while closing the prayer has submitted that the scope is exercising power of certiorari, and therefore the court has to, and the power of certiorari can be exercised under limited conditions. He has referred to judgment passed by the Honorable Supreme Court reported bracket 2003 bracket 06 SCC 675 para 38. In particular, subparagraph 3, 4, 5, 6 and 7 of the same paragraph to submit that none of the conditions mentioned therein is satisfied in the present case and therefore no interference is required. The learned counsel has also submitted that not only the materials on record but also the various judgments have been considered and the improved award cannot be said to be illegal or perverse. With respect to the point of reference, the learned counsel has submitted that the court, while holding that the concerned workmen are entitled for compensation for removing them without notice and without following the procedure under Section 25F of Industrial Disputes Act, has entered into incidental question that was relatable to the terms of reference, as the petitioner themselves had taken a stand before the learned court that the workmen were removed by referring to Section 25F of the Industrial Disputes Act. The learned counsel has further submitted that it was another department of the state government who had referred the dispute for adjudication, and now it is not open to the petitioner to contend that the reference itself was not maintainable on the ground that the petitioner was discharging sovereign function. He has also submitted that there can be no straightforward formula as to whether any department of government is discharging sovereign function or not, and whether it will be covered under within the meaning of Industrial Disputes Act, and the petitioner, having not taken such a plea before the court, is not permitted to raise such a plea for the first time. He has also submitted that such a question is not a pure question of law, rather it's a mixed question of fact and law, and it was for the petitioner to raise such a point before the court so that the matter could have been adjudicated. He submits that in the writ of certiorari, such plea cannot be entertained and the issued order may not be interfered. The learned counsel, while referring to the judgment of this court in reportedly 2024 SCC online JTR 3052 has tried to distinguish the same by submitting that in the said judgment a plea was raised by the department before the concerned court that they are not an industry within the meaning of Industrial Disputes Act, but the court did not frame any issue to that effect, and consequently the award was set as and consequently the issue was framed by this court and the matter was remitted for fresh consideration on the limited ground. The award is set aside here. Yes, and the award was set aside.
Whereas in this case, these are not.
Yes.
Yes.
These points were not raised. He submits that each case has to be seen on its own facts, and the points raised, the evidences adduced by the parties. The learned court has granted a very limited relief to the concerned workmen, in as much as they are entitled for compensation at the rate of ₹1 lakh per head And the learned court has also recorded that although the workmen cannot claim for regularization of their services as a matter of right, but their claim must be considered by the management if cases of similarly situated persons have been considered and their services have been regularized. With a further added that all such exercise should be done at the earliest. That's all.
I'm so grateful.
Arguments continue. ये तो हुआ इसका, बाकी दोनों केस
मैं टेक लेब में
इसमें कौन है? देखिए दो जिसका है उसके साथ लगता है। One five. Who is there in this 1530? The notice is
1530, nobody is happy to know.
Is the notice complete? Item delivered. बताइए इसमें तो item delivered आ गया। Just tell us what is the case here. Just tell us what is the case here. Did you raise a point before the court that you are not in industry? There is a written statement of the government.
In para 3 of the award, it doesn't mention it.
Paragraph 3. Can you read that?
The management in his written statement has stated that after start of construction work of Ajay Barrage, the workmen were employed on need-based also different dates between 76 to 1988. And such employment was temporary and contractual, and payment of daily wages was being made to the workmen. The employment of the workmen was not against sanctioned post, and required procedure as the advertisement, inviting application, sanctioned post, vacant post, qualifications, seniority, reservation, etc. was not followed. In CWJC number 12448 of 1993, which was filed by some workmen, the Honorable Patna High Court had passed direction to take decision whether the workmen could be regularized or not. And in the light of that judgment, Water Resource Department Bihar by dated number 07 dated 1/4/1995 issued order to terminate service of workmen employed after giving them notice in view of Section 25A of Industrial Dispute Act. Due to reduction in workload, the construction work of Ajay Barrage was stopped, and therefore the workmen were required no more, and as such their services was terminated from 1 to 1996 after payment of compensation and 1 month salary in advance. It was further pleaded that thus a dating letter of termination, some workmen moved Honorable Patna High Court in CWJC number 1225 of 1995, in which no relief was granted to them, and it was only observed that if the project work was again started and the state government failed to make appointment on daily wages, then it might consider to employ those workmen. Against that judgment, LPA number 1251 of 1998 was filed, but again the Honorable High Court refused to grant any relief to the workmen. In the year 1998, when the construction work of Ajay Barrage restarted, then in the light of previous judgment of the Honorable Court as well as agreement of workmen with the Ajay Coordination Committee, these workmen along with others were employed in between 1999 to 2000 on daily wages basis, and payment was made to them. From 31/3/2009, no work was being taken from the workmen due to reduction of work after end of construction work of Ajay Barrage. The workmen were employed in the light of judgment of the Honorable Court with the construction of Ajay Barrage, and after completion of the construction work, service of these workmen is no more required, and matter of regularization of these workmen is not pending before the government. It is also pleaded that compensation regarding acquisition of land for the barrage has already been paid. So the demand of regularization of workmen is not possible.
Here also the terms of reference is on
Same, my lord. says whether the non-payment of equal pay and equal work for the equal work and regularization of service of Sri Lakhan Tiwari, Sagar Mohan Singh, Nakul Singh and Sri Balram Prasad by Chief Engineer Water Resource Department thereby justified. Same award has been passed over.
Yes. The PPL number 15304. In spite of service of Mrs. Swami has entered experience of the responsibility. The learned counsel for the petitioner submits that the present is identical point is involved as is involved in the PPL number 1544 of 2024. He has also submitted that the terms of reference is on identical lines and a stand was taken by the petitioner before the court concerned that the workmen were terminated by complying with the provisions of section 25F of Industrial Disputes Act. And in this case also, the learned court ultimately knew that the workmen were not entitled to due wages after 31/3/2009, but they are entitled for wages at the minimum of the pay scale extended to regular employees holding the same post. It has also been ruled that they are entitled for compensation to the tune of ₹1 lakh for removing them without notice and without following the procedure under section 25F of Industrial Disputes Act. And it has also been held that the workmen, that although the workmen were alive, could not claim for regularization of their services as a matter of right, but their claim must be considered by the management if cases of similarly situated persons have been considered and their services have been regularized. And all the exercise was to be done at the earliest. The learned counsel has submitted that. In this case also, though no specific plea was raised with regard to the fact that the state was discharging sovereign function, but the same is a violation of law and that will be entertained in this jurisdiction, as it touches upon the jurisdiction of the learned labor. He has also submitted that the terms of reference did not include the termination of the work. And therefore, the findings of the learned labor court in connection with not following the provisions of section 25F by terminating the workmen is beyond the ये दोनों का कॉमन ऑर्डर है ओके ये तीसरा तीसरा क्या है
3826 of 24.
पहले इसमें क्या है 25F is the term of reference?
Terms of reference is
It was filed under section 2A.
2A clause 2.
What are the points formulated? There are two issues framed.
The paraphone. First issue is whether the petitioners are still continuing their services under the OP and payment has not been made to them by the OP since 31/3/2009 and they are entitled for their wages since then and regularization of their services. Whether services of petitioners have been terminated by the OP after following the provision of 25F of the IDF as claimed by the OP.
25A was the specific issue, and they have filed a petition directly. It is not through a union. So this case came up after that. उसको अलग से बहस करना पड़ेगा ना, सेम नहीं है. फाइलिंग डेट को क्या है इसमें? इसमें 240 days का फाइलिंग है.
But I para 9
यहाँ से पढ़िए. Internal page 16. On the basis of internal page 16.
on the basis of materials available on the record, it appears
There's
to
no right. उसके just एक sentence.
Alright.
एक sentence.
Thus, no right is vested in any daily wager to seek regulation only on the ground of working 240 days in one calendar year. Regulation can only be done in accordance with the rules and not divorce the rules. It is on the basis of materials available on the record. It appears to me that the workmen were employed during construction of the Katia barrage, which has already been completed before 31/3/2009, and all the workmen were knowing this fact. It is admitted fact that all the workmen were designated workers. It is undisputed fact that the claim of the regulation of similarly situated workers of the Katia barrage has already been rejected by the Honorable High Court of Jharkhand. So this court does not find sufficient reason to pass any direction for regularization of services of these workmen. There cannot be any dispute that a post in any administrative government department is created and sanctioned by the state government by following some process, and it is notified about number of posts so sanctioned, nature of post as to whether it is permanent or temporary or contractual or daily wages. There is no material on the record to that post was sanctioned by the state government in construction of barrage at Sikatia, known as Ajay Barrage, and it is as vetted, and the workmen of this case were posted on that sanctioned post, which was vetted at the time of their employment. The workmen have claimed to have employed on the vetted post, but if post was not sanctioned by the state government, there cannot be any question of vacant post. Although the appointment letter of the workmen has not been brought on record either by the workmen or the management to show whether they were employed on the ground of acquisition of their land in the construction of Ajay Barrage or Sikati or otherwise. But it is admitted fact that they were employed in the construction of the said barrage. The project for construction of any barrage has a life for a fixed period or a limited period, and the workmen must be aware of this fact. Therefore, they cannot claim regulation of their service as a matter of right. In the light of above discussion in the issue, it is answered that the workmen are not continuing with their services under the OP since 1/4/2009, and they have received their remuneration till 31/3/2009, and they are not entitled for their wages since then, and they can not claim remuneration for their service as a matter of right. Issue number 2, whether services of the petitioners have been terminated by the OPs after following the provision of 25F of the ID Act claimed by the OPs. The workmen have pleaded that there were services were
There is a
stopped.
clear finding that the work was over on
2009.
But in spite of that, while holding that they are entitled to 25F, it says that the procedure was not. In spite of the fact that the work was already over by that.
2009.
Issue number 3, that finding.
What relief? It has already been found and held that the workmen failed to prove that they were even after 31/3/2009 with the management. It has also been held that provision under Section 25F of the ID Act was not complied with by the management in disengaging the services of the workmen after 31/3/2009. So, although the workmen are not entitled to due wages after 31/3/2009, as claimed by them, but some compensation must be granted to them for removing them from their duties without following due procedure and without notice. The present case has been filed by the workmen in this court on 28/5/2018, that is after more than 9 years from 31/3/2009, which is inordinate delay in filing of this case. However, in the facts and circumstances of this case, in my considered
What
opinion,
is the consequence when the work is not available at all? Because there is a finding that after 31/3/2009,
they have been taken word on the based on the need to base work. Whenever they are required to suffer, they have been engaged. After the completion of that work, they have been disengaged. There is no vacant sanction post.
this may be notice complete.
Yes, well, somebody name is appearing.
Who is there? Whose name is it? Kiska naam hai? Respondent. Rahul Ranjan.
Rahul Ranjan.
Now we are okay, WPA number 3826 of the education. इनका मोबाइल नंबर है ये देखिए खबर में लिखिएगा you are invited in the court to argue your case. This is the language you should do. Right? Invitation? We'll extend invitation to them. Ex parte orders हम लोग को नहीं चाहिए. तब तक आपका सबमिशन ले. WPL number 3826 और 2024. Notice has been served upon the opposite party or upon the respondent who has entered appearance by filing a complaint. The matter has been heard for around half an hour, but half an hour, 15 or 15 minutes, but nobody has turned up to argue the case on behalf of the respondent.
Approximately serial number 18 for the respondents.
Invitation मिल गया? Start. आगे.
Mr. Rahul Ranjan has to appear.
आप राहुल रंजन तो हैं नहीं, तो अप्रॉक्सी में आए.
Madam, just pray for
What prayer? counsel for the petitioner. Has submitted that the proceedings before the Labour Court Workmen started on the basis of petition filed by the petitioners under Section 228 and 2 of the Industry Disputes of 1947, seeking the direction of the management for payment of their wages since 31 K 2009 and regularization of their services with all parties. The council submits that two issues were framed by the concerned court and by the court or the tribunal which is submits that while deciding issue number 1, the court recorded that that there is no right vested in any daily wages to seek regularization only on the ground of working 240 days in one calendar year. Regularization can only be done in accordance with rules and not imposed the rules. It was also recorded that on the basis of materials available on record, it appeared to the court that the workmen were employed during construction of Sikta barrage, which was already completed before 31 2009, and all the workmen knew this fact. It was an admitted fact that all workmen were daily rated workers. It was undisputed fact that the claim for regularization of similarly situated workers of Sikta barrage was already rejected by the High Court. Therefore, the court did not find sufficient reason to pass any direction for regularization of the services of the concerned workmen. The point was answered by holding that the workmen are not continuing with their services since 1/4/2009, and they have received remuneration till 31/4/2009 and are not entitled for wages since then, and they cannot claim regularization of their services anymore. Isn't that in spite of holding that the construction of Sikta barrage was already completed before 31/2009, the court, while deciding issue number 2, recorded that the petitioner could not show that the provision of Section 25F of the Industry Disputes Act was complied with in terminating the services of the workmen after 31/2009. The learned court also recorded that the case was filed after more than 9 years and has awarded compensation at the rate of rupees 25,000 per head. How many workers are there?
203.
3 workers.
200.
The ऊपर लिखिएगा, the learned counsel, वो जो jurisdiction वाला point है, वो इसमें भी है.
One more issue that under section 2A वाला 2A clause 2 वाला there is a first the petitioner has to move before the conciliation officer. Conciliation मतलब thereafter उसमें
आपका
हुआ
ये सब point नहीं है.
but
इतना आसान नहीं है, लेबर मैटर है, बहुत तंग करते हैं आप. 25,000 रुपए के लिए भी हाई कोर्ट है. गवर्नमेंट को 25,000 रुपये तो आपको ज़्यादा ही फीस दे दिया, 2 आदमी का 25,000, 50,000 से कम का बिल मत बनाइए, not a penny less than that. नहीं, सुप्रीम कोर्ट तक लड़ेंगे ना, 25,000 रुपये। वैसे तो आपकी गवर्नमेंट बहुत पैसा मांग रही है, कहाँ पैसे की कमी, कोई कमी नहीं है, वर्कर को देने के लिए पैसा नहीं आता। 25,000 रुपए के लिए आप हाईकोर्ट चले आए, ऑफिस जितना एडवाइस दे 25,000 रुपए के लिए मत लड़ाई करिए। Learned court has no jurisdiction to decide the case, in as much as the state of Jharkhand, that the Department of Water Resources of the state of Jharkhand is not an industry within the meaning of Industrial Disputes Act. He has also submitted that the condition precedent for raising the dispute under section 2A bracket 2 of Industrial Disputes Act was also not satisfied. Very after this. Or at least now a private respondent is not there. He is joining. Yes, Mr. Rahul Ranjan.
Hey, please, your let's know.
Have you
I-
received the invitation on your phone?
Milords, on behalf of me, Milords, Mr. Amit Kumar appearing.
Who is appearing? Nobody is there. Who is appearing?
I handed over the file to Mr. Amitesh Kumar.
आप सुन रहे हैं आपके ऊपर क्या बोल रहे हैं? He has handed over the file to Mr. Amitesh Kumar to argue the case. आपको तो as a senior against कर लिए, आपको धोखा दे दीजिएगा जुम्मन, हाँ? है नहीं? Senior आपको engage कर, junior आपको engage करके आपको senior बनाए, और आप बोलते हैं आपको पता नहीं है, वो बोलते हैं आपको engage कर, किसका बात माने हम? Senior का कि junior का? This is too much. Yes. देखिए इस कोर्ट में सब चीज चलता है, गलत सबमिशन और झूठ तो चलता ही नहीं, ठीक है ना? 7 फीट नीचे से भी खोद के निकाल देते हैं, क्यों नहीं बोले आपको इंग्लिश की?
Milord has instructed me, Milord, engage नहीं किया.
फाइल का आपके पास है कि नहीं? बता दीजिए ना
Yes,
फाइल
Milord,
है,
मेरे पास अभी नहीं है, हुजूर, but
वैसे है
yes,
कल कर लीजिए, इतना सबमिशन लिखा है आपके सामने, यूट्यूब में देख लीजिएगा क्या क्या सबमिशन
I have
लिखा
heard.
है, बस इतना सा पॉइंट बता दीजिए, जब 31/3/2009 रिकॉर्ड कर दिया कि काम ही खत्म हो गया, ये 25F का कहानी कहाँ से आया,
Just on that point.
राइट? The work was over, daily wages, और दूसरा ये कंडीशन प्रेसिडेंट कंसिलिएशन वगैरह में गया था कि नहीं पता, देखना पड़ेगा।
I'll just
मिस्टर क्या नाम बताया इनका?
Rahul.
Mr. Rahul Ranjan, at the end of the Deputation has joined the proceedings through online mode, and Mr. Amritesh Kumar Gyasi has also appeared before this court and has submitted that the matter may be posted tomorrow for the argument on Thursday. Okay?
Yes.
Yes. बाकी तो सेम है। दोनों बाकी दोनों सेम है। दोनों में आर्गुमेंट ये जर्नलिस्टिक से ये वाला जजमेंट है
बाद में This case item 7 WPC 4406 of 2018.
ज़्यादा ही हो गया तो खा लेते क्या नहीं करेंगे
It's a बहुत small matter है. There is a barring provision for entertaining any application either before the civil court or before the executive court. Now here
submissions file किया
हम लोग submit file करें.
State has not filed.
I have not filed.
It may be taken up tomorrow.
Does
No,
require
I'll
also
file it,
the
but I'm in the midst of preparing. The time is also not available. It will take some time because first it has to be established whether this property is a work property or not.
Establish यहाँ थोड़ी होगा
नहीं तो पहले वो डेफिनेशन में फॉल करना चाहिए जो तभी वो ट्रिब्यूनल में जाएगी वो एक दो प्रोविजन खाली दिखा देगा
सिर्फ इतना सा बात करना है
जी
वर्क प्रॉपर्टी का नोटिफिकेशन कब हो चुका है
Yes.
अगर कोई चीज का नोटिफिकेशन हो चुका है whether that property is falling under work property or not who will decide
no, that 2002 notification but that has lapsed that
that's तो होता है क्या इसका कोई
हाँ 2000 वो 2 साल के लिए था उसका मैनेजिंग कमेटी इटैलिक्स में
मैनेजिंग कमेटी की बात है. वर्क लैप्स नहीं करता है.
वो कैसे ला ऐसा तो हमको न्यूज़ में तो नहीं सुन
मतलब committee the committee which was there in 2002 that was for 2 years that has lapsed thereafter
कर दिया लैप्स कर दिया उसका बोलिए टर्म खत्म
हाँ
Yes.
टर्म उसका
खत्म होगा उसका फिर
टर्मिनेशन भी नल एंड वॉइड हो जाएगा
नहीं उसका फिर रिकॉन्स्टिट्यूशन हुआ नहीं
नहीं हुआ कोई बात
and the DC's order that has been set aside by the commissioner we are directed to form the new committee that has been
नहीं
set
इससे
aside
तो फर्क नहीं पड़ता
Ma'am. and
कोर्ट के पास जाएगा ना
and not the whether the property is a work property for that dedication has to be there deed has to be there those things are missing Lord. There is no government with that with respect to that whether there was the dedication thereafter the registration was there whether there was any
तो ये जो वर्क कोड है which has been constituted under the act ये सब स्क्रूटनी नहीं कर सकता
है उसमें दिया हुआ है कि किस
तो
तरह
हम लोग फ्रेम कर देंगे ना
मतलब-
इसमें भी स्क्रूटनी
मतलब उसमें है हुजूर कि वो मतलब कि वो किस तरह के डिस्प्यूट को देखेंगे दैट इज देयर इट सेज कि उनका जो लिस्ट है इन द लिस्ट इफ इट ऑल नॉट देयर इज अ डिस्प्यूट वेदर द प्रॉपर्टी इज अ वर्क प्रॉपर्टी और नॉट देन दैट कैन गो टू बिफोर द ट्रिब्यूनल हियर वी आर सेइंग दैट इट इज नॉट अ वर्क प्रॉपर्टी
वही ना when there is a dispute whether it's a work property or not
Ma'am.
and whether the work itself has been properly created or whatever whether any documentation was required or not required these private respondents cases
Yeah.
that this is a private
Mazhab.
mazhab
Man. No. It's mera. It is a government land. Under the Ganges Service, a government land. Second thing is, my lord, the SPT Act has been enacted under umbrella provision of Schedule 5, read with Article 244, 1 of the Constitution. So there the power has been given and the regularization is there for the schedule area, my lord. Now, so far as Section 20 of the SPT Act is concerned, it is very well it has been enacted under the provision of Schedule 5. Now, my lord, the Waqf Act, as per the Waqf Act and SPT Act, my lord. Now, the Waqf Act will not overrule the SPT Act. Second thing is, my lord, that is there in the written submission, 2 judgments I am giving, wherein parametria 2 instances there, my lord, wherein there was question framed whether this kind of cases, the matter can be referred to the tribunal. So there, my lord, specific paragraphs I'll cite, my lord.
it has been decided?
Yes, my lord. Supreme Court decided. I'll cite the.
Decided that it has to go to the regulator.
No. High Court has that view. If your lordship may permit, may I?
Yes, because it's very interesting.
Yes. So
With
what
respect
I
to-
will do, my lord, I will quote the paragraphs and I'll use this judgment and file it tomorrow, my lord. Can it be kept for
That
next?
judgment is not there.
No. That is the last where research, my lord. We have researched.
हाँ तो ठीक है ना, आप अच्छा से और बढ़िया से research। जब सवाल हम पूछते हैं तब आप रिसर्च करते हैं, अच्छी बात है।
No, that is there, pleaded there, my lord.
Maybe pleaded, but if there is a direct judgment on this,
That is judgment.
then that has to be taken care of.
Yes, my lord.
आपका भी written submission तैयार है।
Next, it can be kept on next week, Monday, my lord. Everything will be.
तो assign yes है नहीं?
No.
छुट्टी के पहले कितना काम करेंगे?
Subject to my lord's convenience. Monday, we can get lordship.
I am relying on two decisions, Lordship. That is Patna High Court decision. I have already supplied the decision, and another is of the Supreme
कैसे
Court.
आपको मिला और हमको नहीं मिला, हमको बहुत खुशी।
What
How can he say, Lordship? Even if the dispute is
पंजाब
there.
में हरियाणा का
Yes.
मिला। मिला कि नहीं मिला?
हाँ वो मिला था इसमें बोला गया ना हुजूर
उसको कहीं रखे हैं, उसको किसको भेजा? एक पंजाब में हरियाणा।
unfortunately one of my intern, he was interning in my office. I distributed the work for research. He researched it and very well. I'll cite the judgments, my lord.
तो फिर उनसे मिलना पड़ेगा। Where is he?
Today I didn't came. He's from NUSR Ranchi.
तो अगला डेट में उनको लेके
एकदम
और अपना रिटन सबमिशन
फाइल कर दिए जजमेंट हम डाल देते हैं.
जजमेंट सब डाल दीजिए। इसको थोड़ा सुनते हैं।
Yes, madam.
टेस्टिंग है, इसको थोड़ा सुनते हैं।
Yes, madam.
अगर होगा तो डिसाइड कर
Yes,
देंगे।
my lord.
नहीं तो आपकी किस्मत में जो बेंच होगा।
Yes. Tomorrow I'll give the judgments.
क्या नाम है आपका रिसर्चर?
Who research, my lord? Nikhil Ranjan.
निखिल नहीं।
He's of 4th year. Yes, he did the research. Honestly.
पहले बढ़िया से काम करा रहे होंगे तभी ना रिसर्च कर पाएंगे।
हाँ ये मैं करके दे दूंगा. कल दे दूंगा.
वापस कर दूँ.
हाँ.
Learned counsel for the parties are present. The learned counsel for the petitioner.
I am for the
ये
petitioner.
आपका है?
That is there.
आपका है?
हाँ.
ये क्या है?
Written submission.
The learned counsel for the state has submitted that he is in the process of preparing the written note of argument. The learned counsel for the private respondent has submitted that he would lay hands on certain judgments and he would file those judgments and if required revise the written notes
My lord.
or give supplementary written notes. As Tuesday.
Monday.
Post this case on next week.
Next Monday.
हम बहुत खोजे हैं वो पंजाब एंड हरियाणा वाला कहाँ है वो जजमेंट आप लगाएं?
नहीं इसको नहीं लगाए. I got that. उसको भी ले आएंगे. और those judgment has been means it has been discussed.
आप लोग को नहीं मिला पंजाब हरियाणा?
I have given one judgment of Patna High Court.
झारखंड में मत अटक के रहिए। हर जगह इस तरह का इशू होता है। बेटर रिसर्च बताइए 4th ईयर का स्टूडेंट रिसर्च कर सकता है। आप लोग नहीं सकते हैं।
तो फैक्ट तो देखा जाए ना, फैक्ट एप्लीकेबल है कि नहीं केस का होगा, because he is relying on
Ratio, the ratio.
the facts of the ratio of the ratio. Different fact.
पासिबल है कौन सा पासिबल?
I can quote.
Lordship, Lordship, this is a very short matter, Lordship. The factual background of the case is, Lordship, that there are 5 major units of sale located across the country: Bokaro, Hilai, Raurkela, Durgapur, and Banpur, Lordship. Lordship, the petitioner before your Lordships is the one registered trade union which is working for non-executive members, Lordship, of employer in the Bokaro Steel Plant. The petitioner has prayed before your lordship for mandamus for compelling the respondent authorities to conduct trade union elections in the same plant, Bokaro.
Is this reputation maintainable? They have an objection with regard to maintainability.
Whatever objection they have, lordship, I will sort dispel that objection.
They have filed this judgment. Have you seen that?
I had given a citation to the
Let us see the first.
Para number 12.
Yes, I'm coming to that. Paragraph 12, I'm reading. A perusal of analysis of the provisions of the Trade Union Act clearly demonstrate that the right conferred under the Trade Union Acts for holding elections is subject to the aforesaid Act and is neither a fundamental right nor a common law right. A close analysis of the aforesaid provisions further demonstrates that the elections held in pursuance to the scheme of the Trade Union Acts are not subject to any challenge under any provision of the statutes, namely Trade Union Acts. In other words, from the scheme stated above, it is clear that the said statute does not provide any machinery for challenging the elections held under the said Act, and the registrar has absolutely no right. Here I pause, Lordship. Registrar. Then after, authority or jurisdiction to adjudicate upon any election set up by any rival faction of or any other person. The ladyship, the first point is that this I am praying for the trade recognition of trade union election by the mode of secret ballot. This is not the case of rival faction within the trade union, office bearer. This is not the case of office bearer of within the trade
So
union.
you
Ladyship.
want that it should be done through secret ballot.
Secret ballot.
So you
That
think your-
squarely will cover, ladyship.
You think your bylaws that the election will be held through secret ballot. Why a manifest will be? Is there any law that there should be a secret ballot?
Yes, ladyship.
Under which law do you say that you can claim this mandamus?
My case will be squarely covered under the judgment passed by the Apex Court, ladyship, that is the judgment of Food Corporation of India, the Staff Union versus Food Corporation of India and others. Citation, ladyship, 1995 Supplementary Volume 1 Supreme SCC 678, ladyship. I'll provide the case.
SCC
678, ladyship.
67.
I'm giving the
Supreme
copy.
Court cases?
Yes, ladyship. I'm giving the copy, ladyship.
That all the elections are to be held through secret ballot?
I'm reading that paragraph. I'm going through that, ladyship. That. Mode of determining representative character of trade union for the purpose of parties, here Food Corporation of India, agreeing to follow secret ballot system but differing in matter of procedure. In such circumstances, detailed norms and procedure laid down by the Supreme Court and registration for 1 year laid down as condition for eligibility of.
Agreeing to follow secret ballot. Where is that agreement? Where is that agreement in your
Let us-
case
I'll-
that you are agreeing to follow secret ballot, but still you are not following secret ballot?
Because it is the union, it has been at least 50 to 40 to 50 years has been elapsed, ladyship, that Bokaro Steel Plant has never conducted any trade union election. And that's why we are the recognized, we are the trade union registered by under the Jharkhand state government. So we have wrote letter to different authorities, including the director in charge and the chief labor commissioner also, for conducting the fair election and recognition of trade unions. There are no any single trade union recognized as a trade union in Bokaro Steel Plant. While in other states such as Odisha and Chhattisgarh, there are the procedure by which they follow the secret ballot election. Recently, one judgment order has been passed in Odisha High Court, Ladyship.
So you are seeking a mandamus, right?
Yes, Ladyship.
And then what is the cause of action for you to come before this court?
Because of action, Ladyship, that I wrote letter to concerned authorities for conducting a fair election. And
Fair election means there were unfair
election is
elections?
no, it is general term, Ladyship. However, election.
Your Ladyship, there is no provision in Trade Union Act regarding elections. If he may refer to a single provision that shows that there is elections to be conducted, not a single provision talks about elections or any authority to conduct elections in the manner that he states.
40 to 50 years, no election has been conducted.
No trade union election has been conducted. Now, the Trade Union Act, Ladyship, FCI judgment squarely covers, and the condition also which has to be followed.
Your
The
Ladyship,
PL number you find it from.
when
The PL number 6460 of when it comes to the parties are present. When it comes for the respondents are submitted that the present petition is not eligible. The counsel for the petitioner has submitted that in spite of lapse of more than 40 to 50 years, the election has not been conducted. Election of trade union has not been conducted. And he is seeking a direction that election be conducted through secret ballot papers. And has relied upon the judgment passed by the Honorable Supreme Court reported in 1995, supplementary United 1 SCC 678, and in particular has referred to paragraph 3 of the judgment, which refers to notice instruction number 25 of 1980 dated 18/12/1980, issued by the Office of Chief Labour Commissioner, Ministry of Labour, Government of India. And he submits that there is a provision for conducting election through secret ballot.
And one more order is
However, he has not been able to show the provision of law under which provision of law or the memorandum under which the election was to be conducted.
Ladyship.
Let the counter affidavit be filed by the respondents. Who will file it?
BSI will find it. I mean, respond number 5.
Respondent number 5. Are we filed it?
For the state.
Your Ladyship, the basic remedy that he has sought is against respondent number 4 as well.
Okay.
Direction upon respondent number 4 to conduct.
The
That
counsel
is
for the respondent number 2 is present. He shall also seek election, instruction and file counter affidavit. Let the counter affidavit be also filed by respondent number 2 and 4. Let a copy of this order be communicated to your ASTI for compliance. उनका नाम नहीं अपील करना है ASTI के ऑफिस में.
In the morning, someone was appearing with my lordship.
Ladyship, one order of coordinate bench of this honorable court. Coordinate. Ladyship, this order was passed in a writ petition. Kindly it may be
The
referred.
counsel for the petitioner has also relied upon an order passed by this court in WPL number 5503 of 2010 dated 10/8/2020. Responding to excitation, she has to rely upon judgment passed by Honorable Allahabad High Court reported in 2002 SCC 19
Para 13.
सोलह
एक जरा सा छोटा सा सबमिशन था इस टाइम सीरियल 32 में वो हियरिंग के लिए फिक्स्ड है केस, लेकिन गवर्नमेंट ने उसने एलसीआर का ऑर्डर दिया था। प्रिजाइडिंग ऑफिसर आज 6 मंथ्स हो गया एलसीआर भेज नहीं रहे, इसको कल सप्लीमेंट्री में पोस्ट कर दीजिए ना कि रिमाइंडर हो सके। 32 2010 का मिनिमम वेजेस एक्ट का केस एडमिटेड मैटर 32